You should write your will right now. Many people do not consider that. And first of all, let me be very clear. Not writing your will is a huge mistake. And it's a huge mistake, first of all, because you cannot write a will retrospectively, and especially if you are not an Italian citizen or you possibly do not speak the language and your family is abroad, you are creating a very distressed situation on your estate, on your issue. Why? Because then they have to deal with the Italian bureaucracy at its max. So let me explain you. So in case you do not write a will and you die in Italy as a resident, then you're also liable to pay inheritance taxes. But as we know, inheritance taxes are not that high. However, the bureaucracy involved in releasing your estate is crazy. Why? Because that has to be administered by someone in Italy. And if you did not appoint anyone to administer your estate, then a notary will do that. And if your family, if your issue, they live abroad, how do you communicate with them? Well, the first option is that they come over Italy and resolve the issue, or they appoint a lawyer, giving them, him or her, the power of attorney and a proxy to deal with your issues. And then they also have to provide multiple documents which are notarized and with an apostille to travel from the foreign jurisdiction to Italy. So it's really easy that a simple estate takes years before appointing the asset to the actual issue. So appoint the asset to the people they want. And on top of that, the Italian inheritance law are very strict. So you cannot disinherit anyone. You cannot decide to ascend all or part of your wealth as you wish. In fact, there are strict percentages based on the type of relationship with your, like if you have a spouse or if you haven't, how many children do you have, what is your disposable estate, how many items you can appoint out, how long can I claim any donation made during the lifetime. Italy is a very complicated matter, and oftentimes a disputed estate ends up in court, and it might take years, even 20 years to resolve that. So my advice is literally simple, and you have to sit down with a lawyer or an accountant, and possibly both, to figure out what's the best solution for your will. And especially if you are a EU citizen, you can write a will appointing the jurisdiction or the applicable laws to your estate. So let's say that you are a French citizen and you want that your estate is administered under the French legislation. Well, in that case, you are only liable to pay tax and to deal with the Italian bureaucracy only in regards to your Italian assets. So the whole procedure is taken care in France. If you have family there, of course, it's way faster, it's simpler, but you might have a little bit of complication in Italy. For instance, releasing your bank account, releasing the estate, appoint a notary to transfer the properties, etc., etc. But it's far simpler than administer everything from Italy with your family abroad. So once again, if you didn't do that, write your will, make sure it's compliant, and make sure to decide which governing law to apply to your estate. And if you don't like that, remember that you can change it down the road. So the will is not forever. You can change it anytime, and you can amend it based on the changes that happens in your estate or in your family or in any legal jurisdiction during the time.